Good afternoon. I'm Drew Spaniel, the founder and director of research for Mission Critical, a nonprofit that facilitates collaboration between academia, industry, and government to develop and disseminate interdisciplinary, peer-reviewed, technical and non-technical research that is focused on improving critical infrastructure security and resilience. Today, on our Critical Insights series, we are joined by the esteemed Mission Critical Fellow and Advisor, Robert Metzger, who is the head of the Washington office of Rogers Joseph O'Donnell. Bob was a member of the Defense Science Board Task Force that produced the Cyber Supply Chain Report in April 2017 and is the co-author of the 2018 MITRE Deliver on Compromise Report, which has influenced subsequent DoD cyber and supply chain security measures, including CMMC. As a consultant to MITRE, Bob worked on cyber, supply chain, and digital asset crime projects between 2017 and 2022. He was also a 2016 Federal 100 awardee. His legal practice includes cyber, supply chain, and national security matters, and in 2024, he was honored in LawDragon's inaugural 500 Leading Global Cyber Lawyers Guide, and he was named a top voice by LinkedIn. The international lawyer ranking firm Chambers afforded Band 1 recognition to Bob in its USA government contracts cybersecurity rankings. This is the highest Chambers ranking an attorney can receive. He has also been recognized by the Chambers for Government Contracts for 14 consecutive years and is presently ranked in Band 2. Mr. Metzger is active in the Science and Technology section of the American Bar Association and serves as the Vice Chair of the Information Security Committee and the Co-Chair of the Trust and Risk Committee. Welcome, Bob. I'm excited to hear your perspective on today's topic.
Thank you.
And as a general disclaimer, all mission critical publications, content, and these Critical Insights interviews are nonpartisan because we are a nonpartisan organization, and especially in these Critical Insights interviews, all views discussed are those of the individual and are presented only as informed opinion. I think for today's video, we should also emphasize that any opinions discussed are only opinions, and they are in no way, shape, or form legal guidance. Feel free to reach out to Mr. Metzger, though, if you would like a legal consultation. Is that a fair statement?
Sure. I mean, I can answer some questions informally, but we're going to be talking about some rather complex items, and I'm going to try to address them succinctly. But things are always more complicated in the law than one might think, and this area is especially complicated.
Yeah, I think this is definitely an exciting discussion, if only because it's kind of maybe unexplored or unanticipatable territory, despite our title. We don't know exactly where things are going to land, but there's, again, sort of an informed guess. But for our audience, can you, again, I understand this is a very complex and in-depth topic, but at a very high level for a more general audience, can you just explain what the Chevron Deference was?
Okay, so in 1946, some years after the New Deal, Congress was a little bit wary about the expansion of the administrative state, and so it passed something called the Administrative Procedure Act, which essentially tells agencies how they are supposed to go about rulemaking. And if you read it, it seems to say that courts have the responsibility to resolve questions of law that might arise if rulemaking is contested. But then in 1984, in the so-called Chevron decision, the court introduced a new and quite different way of approaching judicial review of agency rulemaking. Typically, we discuss Chevron as having two steps. The first step is for the court to look to see whether the agency actually spoke definitively about the issue that has been brought into question by a lawsuit. And if it did, then the inquiry is over. But if the agency did not speak definitively, if there was uncertainty or ambiguity, then you'd move to step 2 under the Chevron deference, by which the court decided that it would give deference to any permissible agency interpretation of the statutory area that was ambiguous or uncertain. And we call this Chevron deference because the doctrine came to be known and was sometimes used by courts to avoid imposing their own judgment as a matter of law on the soundness of agency rulemaking. And instead, it is often associated with some years of court deference to contested agency actions. Now, things are always more complicated than they seem. The first 10 years of Chevron, it was largely ignored by the judiciary. Only about in 1994 did courts start to issue opinions in which they cited Chevron and gave deference to agencies. But beginning around 8 years ago, in 2016, it became evident that the Supreme Court, among other courts, was having some real questions as to whether Chevron was a good practice, was legally permissible, constitutionally allowable, or workable. And so, the public headlines say that Chevron was repealed by this Loper-Bright decision a few weeks ago, and it would have you think that suddenly the rug was pulled out from dozens or hundreds of agency regulations and prior judicial decisions, only to be substituted with a new role for activist courts. Well, that's not exactly what really happened, Drew. Those who follow this area of administrative law have sometimes referred to Chevron as a zombie doctrine for the last 8 years, basically one that people will occasionally mention as a way to justify a decision, but one that is rarely relied upon and certainly hasn't been given the same traction by the Supreme Court. And so we have this new Loper-Bright decision in which the Chief Justice, Justice Roberts, said, putting it simply, I can't reconcile this Chevron deference with the plain words of the Administrative Procedure Act. The APA says it's for courts to decide issues of law, and if there is an ambiguity, the APA would call on courts to use their traditional means of interpretation to decide as a matter of law how to resolve the ambiguity. And he says, to paraphrase, you can look forever in the APA and you'll find nothing that talks about giving deference to ambiguous statutes or agency interpretations of uncertain statutory commands. Now, there's a whole lot of additional gloss and complication that attaches to this. And there is a huge amount of attention because, conceptually, there could be many years of prior regulations that some people think might suddenly be exposed to a new judicial challenge. And other people wonder, as you do, Drew, as to what does this mean for recent agency rules, or ones that are pending or ones that are coming? Well, they're all good questions, but I will start by saying that this area definitely merits attention and study, but it is not a, precipitous change in polarity from black to white. And also, I'll volunteer this further opinion. A lot of the people that are most upset about the Loper-Bright decision are concerned that the discretion of agencies to execute political will or to achieve policy objectives, beyond the strict words of legislation will be curtailed. That's probably true. And what that might mean is that the APA could not go off and issue regulations on car emissions if there wasn't some statutory basis to do so. No, very likely. On the other hand, how you actually feel about what we call the cabining of the administrative state may well depend on kind of who's running that state. So today, liberals, I guess I'm usually one, liberals would say, gee, I'd sure like the agencies to do the right things that this administration wants them to do, even if maybe the statutes aren't quite that clear. But supposing that the other guy were returned to the presidency next January, well, in that situation, you would have, the new right in charge, and they would probably like to have the same latitude for the administrative state, but for rather radically different purposes. And so it's been said, not just by me, it's been said that, well, what's good for the goose is good for the gander. And therefore, if you're a liberal who's frustrated by the limitation of the administrative state by reason of Chevron's repeal, you might be very happy that that same administrative state is limited should Mr. Trump again become president.
Yeah, I think that's a great kind of synopsis again of a very large and complicated topic. I guess the first couple questions I have, you touched on in that response. So maybe going back and then forward, if you don't mind.
Sure.
So to your point, it's maybe a misconception or not a full encapsulation of the issue to just assume that the repeal is a negative, and I think that's a fair assessment. And we'll get into this maybe a little bit.
Well, let me stop right there.
Yeah.
So, often the decision of an individual, whether this repeal is a negative, focuses on what they think the impact will be for their
Absolutely.
personal political or policy objectives. And
Right.
so, looking at the dissenters, you would say, well, there are things about the administrative state where I want them to do good things and achieve good policies, and I want agencies to have more flexibility to do those things without being troubled with clear statutory authority or the intervention of courts to consider the legality of what they do. But that's not quite the same thing as having a sound legal basis to criticize. I'm not, the world's finest administrative law lawyer, but I have a little bit of respect for it and some knowledge. And, my view is pretty consistent with what the Chief Justice said, namely that the Chevron doctrine is really hard to reconcile with what the Administrative Procedure Act clearly says,
Right.
and that the Chevron doctrine wasn't particularly workable, and that it led to, inconsistent, if not arbitrary results. And so, in my view, does it change the burdens on agencies or litigants? Does it change expectations of companies who are regulated? Yeah, it can in some places more, and some places less. But I would not be too quick to jump to the conclusion that this is some radical transformation by which, the world shifts on its axis. I don't think it's going to play out that way.
And I think that that's also a great insight. And that did kind of, maybe my phrasing was poorly when I framed it as maybe a negative interpretation, but I think that is how it's being understood by, in the media and by those not in the legal field. So I think that's why explanations like that are actually really meaningful. What I was going to ask is, and you did touch on this already, but I don't think things are as cataclysmic as maybe they were initially presumed. But how, broadly speaking, how might the repeal of the Chevron deference impact either the pace of cybersecurity regulation with regards to critical infrastructure, or even the consideration of whether or not to regulate certain issues within critical infrastructure?
Well, that's kind of the money question, if you will. But as is always true in kind of complex legal analysis, the answer is it depends.
Yeah.
So let's sort of break that into some components. Chevron is repealed, but the Chief Justice said that the repeal of Chevron does not actually undo all of the regulations that may have been entered into and then challenged and confirmed, with some reference to Chevron. There's this concept called stare decisis, which means the courts generally will give continuing respect to a decision that's made, even if there is some later reason to question it. So we have to start with the assumption that most existing statutes, are likely to remain immune from an attack under the APA, notwithstanding the repeal of Chevron. And one reason is that if an existing statute is clearly within the agency's authority to act where there is underlying statutory basis, and there is a rational explanation, which is the best of the possibilities, the courts may have cited Chevron to uphold that regulation, but really they'd come to the same conclusion if it had been challenged under the new rules. So we should start from the assumption that most rules that already exist are going to remain intact, even if some are challenged. I said most. I did not say all, because there are examples, sometimes well publicized, where agencies will try to achieve things that have great political appeal, say the waiver of student loans, or the extension of emissions policies, or the coverage of contraception under the Affordable Care Act. I think those are good examples.
Yeah.
Agencies will sometimes try to do things where the agency will think it's consistent with what the president understands the legislation to achieve, but there really isn't any statutory basis for it. And the regulations themselves, essentially depart from a political premise rather than a legal basis in the underlying statute. To the extent that such regulations remain in place and in force, there is the possibility, even now, that by reason of the Chevron repeal, that there will be challenges to such regulations. Let's talk for a moment about how that applies in the cyber area. Well, for regulations that are presently pending, where people have an underlying statutory basis and there's good reasoning in the rulemaking record, I think you're likely to be okay. But there are a couple of areas where different entities in the federal government have decided to impose rules that affect critical infrastructure that are pretty hard to find sourced, if you will, in an underlying statute. You'll recall that the EPA tried a year or two ago to impose regulations, cyber regulations on water treatment facilities.
Yep.
And that was challenged under the APA as being arbitrary and capricious and without a basis in law, because there isn't anything in the statute that says you can do that. And the EPA withdrew the rules. Currently, we have some actions that the FTC is attempting to do, where I'm not sure that you could find anything in the FTC Act or its existing statutes that will authorize its explicit movement into specific cyber regulations. And the SEC obviously has issued some very powerful rules and is now litigating an aggressive case against SolarWinds. Now, I haven't studied this, anywhere near the level that I would if I actually were retained in challenging this thing or defending it. But those strike me, the FTC, the FCC, and the SEC, they strike me as areas where well-meaning regulations and initiatives are underway to achieve cyber objectives important to critical infrastructure, but where when you kind of look under the rug, it's sort of hard to see a statute there. And
I would agree on that. Yeah.
I said earlier that there's sort of two steps to Chevron, and that's how it's typically discussed. But a lot of analysts would say there's actually a step 0 as well. You don't even get to Chevron if you don't pass step 0. Step 0 is there a statute here that authorizes this in the first place? And where there isn't, it's not going to matter whether you apply the Chevron doctrine or not, because you won't get to a point where a court would consider deference. It will decide that the agency is acting without the underlying statutory authority, and therefore such regulations are exposed exposed to challenge under the APA. And Loper-Bright doesn't create that basis to challenge, but it does clarify how the court should approach it. Now, let me go on for a minute. I know I'm rattling on here.
No, you're fine.
So we've got, the past regulations where some are exposed and some not. Then we have some pending regulations. Let's take the CERCIA regulation, right? That one says that anybody who's got critical infrastructure has got to make all these reporting things and commit to all of these activities and allow access to various features and functions. And there is an underlying statute, CERCIA, that says that DHS should issue regulations that require people to report on challenges to critical infrastructure. So there's a statutory basis there. The problem with the CERCIA regulation is that when it was published, it was 110 pages in the Federal Register, or 440 pages, on 8x11 paper. One could look at the statute and then compare the proposed regulation, and you might ask the question, wow, there's an awful lot of stuff here that isn't just an extrapolation or an expansion. It's a sort of an explosion of possibilities that you might attribute back to the statute, but which you might decide represent, agency enthusiasm over foundation. And so I think there is some exposure on the CERCIA rules simply because, there's a point where you can exceed the boundary of the statutory authorization you have. And if you get into excessive flights of enthusiasm, however well-intended, that cannot be tacked back to something that Congress authorized you to do, I think you're looking at some exposure. But there's another one that has even more exposure. I think last October, GSA, DOD, and maybe DHS, they came up with a proposed rule. And it said essentially that anybody who's a federal contractor who suffers a cyber incident has to make a prompt report and agree to let government law enforcement into their facilities. And you also, I think, had to agree there that you would have software assurance, including SBOMs. Now, I didn't have a chance to go back and look at the reg. I have studied it. In fact, I've tried to forget it, but I didn't go back and look at it this morning. Well, I mean, that's a very interesting regulation. I thought it was a horrible overreach in any case. But if you look at the start of the proposed rule, you're not going to find any statutory reference at all, because the basis of that proposed cyber rule is Executive Order 14028, which is not a statute. And so even if somehow Chevron Deference were to reappear just for the challenge to that, GSA cyber incident reporting rule, it's not going to do you any good, because Chevron Deference is built upon essentially a notion that Congress passed a statute that gave you authority to do something and then didn't tell you how to do it, and we, courts, should allow you to decide, agency, how to do it. Well, if the authority isn't there, obviously you're not going to get to the point of deference. So that's an example, of rulemaking that I think could be vulnerable to challenge. Now let's take one more, if you don't mind my rattling on. So, I've been attached to the CMMC initiative since before it was CMMC. That was the MITRE report and other stuff. And CMMC had a proposed rule that came out on December 26th. And it was also very long and very elaborate. It's a very complex rule. And there's like 30 pages in the Federal Register that explain, why they're doing this and how it's supposed to work. Well, when I first attempted to read it, ruining my Christmas holiday, a part of me thought, why are we spending thousands and thousands of words with all of this explanation as to the history, purpose, operation, meaning, and significance? Why are we doing all this when everybody who actually knows this stuff already knows this stuff? I don't need to read this. I already know it. Then a light went on a little bit later, and it, went on a little more brightly after Loper Bright's decision overruling Chevron. I said, the Office of the General Counsel at DOD is undoubtedly aware that since 2016, the Supreme Court has been more or less an active retreat from Chevron, and that since 2016's decision, which was, I think, Encino Motors versus, Encino Motor Cars versus Navarro, since that time, there's been flight by many district court and appellate courts from reliance upon Chevron. The fact that, look, if you have a statute that's challenged, well, during Chevron, you could say, hey, it's ambiguous. Congress wants me, the agency, to decide. You, court, get out of the way. Well, you can't do that anymore. And you really had risk of doing that even after 2016. But does that mean that agency decisions are always wrong? Does that mean that courts are free to ignore, agency rulemaking explanation? No, it does not. In fact, even the decision in Loper Bright says very clearly, and going back all the way to the Constitution and original founding cases of the Supreme Court, it says that when courts are interpreting law as to statutes, courts are to give respect to the agency action because it does have expertise. Respect isn't deference. Respect means that you take into account what the agency did and said, and their knowledge, making your decision as to whether a statute should be interpreted as X or Y legally. And so if you have a regulation that was issued with a thorough basis of explanation in the Federal Register, and if it is clear, as it should be, in the Federal Register that there was a statutory basis, and if you hew approximately in your regulation to what the statute allows and avoid what it doesn't, well, if that's challenged today, even if we've never heard of Chevron, it's going to be sustained. And I think most courts that will be facing new regulatory challenges, they will give no deference to agencies just because an agency exists, but they will pay attention to the thoroughness and soundness of the reasoning that the agency produces to justify a regulation. And that gets me all the way to CMMC. One thing I hope will happen is that if CMMC regulations were challenged under the APA, that a court would say, wow, there's an awful lot of explanation as to why they're doing this. And there is actually some statutory foundation, especially in the 2020 NDAA, which requires DOD to impose a cyber framework.
Right.
And so, I don't have to give deference to DOD, but I think the reasoning is sufficient, and I should respect DOD's reasoning, and I find no basis to question whether it extends beyond statute. So what I'm trying to say is that, for regulations that have been in the works for a while, I think in many cases, maybe most, the agency general counsel ought to have known for years that it's a fool's bet to assume that Chevron will save you if you don't have authority and you're challenged under the APA. And I think there will be even more of that now that Chevron has been repealed officially, and there'll be less, let's call them, zealous initiatives, as perhaps you might characterize the FTC. There will be less of that because there's a even lower likelihood that your activities would be sustained if they're challenged. Now, I want to go back to, if I might, the CMMC for 1 second.
Sure.
Why? Well, I mean, CMMC regulation should be final within a couple of months, and it's going to affect at least 70,000 companies. The regulation will require a certification assessment if you want to continue to do business with the DoD. And the defense industrial base is a critical infrastructure element itself.
Right.
Well, people ask me all the time, do you think those rules are now vulnerable to challenge because Chevron was repealed? Well, not because Chevron was repealed, and maybe not at all. Because here's something people don't often understand, which they should. Chevron is a decision made about how to apply the Administrative Procedure Act. And the repeal of Chevron Deference means that challenges under the APA are going to be decided differently than before. But CMMC is an example of federal procurement rulemaking. The FAR is federal procurement rules. The DFARS, or the NASA FAR supplement, agency procurement rules are not subject to the APA. They are explicitly outside the APA. And they are subject instead to the OFPP Act, Office of Federal Procurement Policy. Now, the rulemaking process looks a lot alike. Notice and comment rulemaking, interim rules and proposed rules and final rules and so forth. The process is very similar, often identical to APA rulemaking, but it is literally a statutory truth that procurement regulations are not subject to the APA. And if you are challenging a CMMC contract requirement as it applies to you, would affect your performance, deny you opportunity, or cost you money, well, you can't bring that as an APA challenge. First, because the APA doesn't apply to a procurement rule. And second, because of a doctrine within the APA that says, I'm going to waive sovereign immunity for certain types of challenges to federal statutes and regulations. But I'm not going to waive sovereign immunity everywhere and for anything to anybody. One of the exceptions to the APA waiver of sovereign immunity is in situations where the challenge to a regulation is expressly or impliedly forbidden by some other statute. Now, what am I talking about? Drew, have you ever heard of the Contract Disputes Act?
I've heard of it
a little bit.
Haven't read it.
So the Contract Disputes Act was enacted quite a few years ago. And the Contract Disputes Act says, hey, as to anything that is a procurement dispute, as to issues arising under a government contract, we're going to set up a special administrative mechanism for claims, and we're going to tell you, the claimant, that you have two choices of where to bring those claims. One is to the Court of Federal Claims, a specialized tribunal, not an Article III tribunal like federal courts. No. And the other is to a contract appeals board. Well, there's a case that was decided in the Ninth Circuit out in the West Coast in 2023 that's been followed so far. It essentially says, if you got a grievance, if you're a contractor and you have a grievance as to a procurement regulation, don't bother me under the APA. The APA doesn't waive sovereign immunity as to you. The APA says that you have an exclusive remedy created by another statute, which is the Contract Disputes Act, and go to the Court of Federal Claims or make a claim to your contracting officer and go to the Contract Appeals Board. Most potential grievances that will arise with respect to DoD's cyber regulations are likely to be, if I'm in the Department of Justice or military department and somebody brings an APA claim trying to invalidate a CMMC rule, the first thing I'm going to say is that the APA has nothing to do with the procurement regulation, and that's what CMMC is, so there's no jurisdiction.
Right.
And the second thing I'm going to say is that even if the APA somehow did allow jurisdiction, there's no waiver of sovereign immunity because this thing should be put through the Contract Disputes Act. And then if it's a trade association or something that says, get rid of this whole rule, it's just too burdensome and there's an insufficient statutory basis, if that comes around, well, you're going to try the first two arguments, and then you're going to say, look, contract isn't a right. These regulations of CMMC, these are things that you essentially choose to accept if you want to bid for and take a government contract.
Right.
And so I would say to the trade association challenging CMMC, you don't have any standing. You're not a contractor. You're just an outsider. Right. If one of your members has a problem, they can take it up with their contracting officer. If they're not happy, well, they can raise that, in a claim under the CDA. Now, there's always asterisks. I should have like a standing asterisk in the screen. And the asterisk here is, the ingenuity of lawyers is never defeated even by, facile discussions just as I've given. So I'm now going to flip my hat, and I'm now representing one of those trade associations, and I'm going to try to get a federal court to take jurisdiction over this. And what I'm going to say there is, well, I'm not actually challenging the contractual implementation of CMMC. I'm arguing that the fundamental regulations don't have a sufficient statutory basis. And I might even try an argument that I don't think it's a good one, there are elements of CMMC that are conferring certain judicial or executive authority to the private sector.
Right.
In other words, I try to find something as far away from the contract nexus as I could and hope that a court might be willing to hear it. And if they were to hear it at a federal district court under APA, which I think is pretty unlikely, well, that's where it's going to be helpful to have that lengthy explanation of why are we doing this and why are we doing it this way.
I think those were great examples. That's why I kind of just let you go there. And I think that covers a lot of what I, as someone outside of the legal profession, would have asked. I guess what I think to maybe as a boil down, would it be a fair maybe summary or fair statement to say that the decision to repeal the Chevron deference is sort of a shift of responsibility back from sort of assumed agency authority to the legislators for crafting more detailed, more specific, more actionable legislation?
And yes.
Okay, fair.
Okay, so the no
I think that's the answer to all good questions.
As to statutes that already exist, the legislature has said what it says. And inevitably, there will be situations where even well-crafted statutes don't answer all of the issues that may arise, and where new questions come up as to how a statute should be applied to a new problem or objective. Well, you can't really, in theory, you could go back and ask Congress to amend the statute to clarify it or give new authority, and maybe that'll happen. But it doesn't have to happen because what really Chevron does is to say that the courts are going to have a bigger role in deciding what agencies do with those new problems. Instead of letting an agency decide on its own initiative to add new requirements to an industry reflecting a new societal problem, well, now the agency is going to have to be more careful to see if it can pin it to a statute and justify its action in accordance with the statute. But it will mean that courts are going to have courts will more often have the decisive role in determining whether the agency's action or interpretation or regulations are legal. And let me go off on two different veins momentarily.
Sure.
Now, if Congress wants to avoid this fostering of increased administrative litigation, there are ways it can do it. It can be more elaborate in its statutes and more precise as to what it allows and what it doesn't. And in the perfect world that does not exist, with a highly functioning Congress where there's bipartisan and bicameral agreement on complex issues with political differences and contrasting technical approaches. In the perfect world, Congress produce more detailed regulation with clearer authority that reflected or answered more of the questions that will come over the life of the statute. Well, it might happen, but you can't assume that it will happen because Congress doesn't really work that way under the best of circumstances, and contemporary Congresses, are not suddenly going to be motivated by the Loper-Bright decision to do wonderful work, which they haven't been able to do consistently over the last few years anyway.
Right.
So we're still going to be.
I think
sorry.
No, it's fine. Sorry to interrupt you there. I think where I've heard the most feedback about Chevron with regards to the legislation, which is sort of maybe the legislation sides where I'm a little more familiar, has been the norm right now is, Congress just in a bill saying, and DHS go and figure out how to do this. And that's sort of been the end all be all. So when I say more specific, does Congress now need
still
to?
Out there.
Okay.
I mean, I'll interrupt again. So,
no, it's fine.
No, Congress does that a lot. I mean, sometimes
Right.
they don't know enough, so they let DHS decide, and sometimes they can't agree enough, so they figure the agency will work it out. But understand that if you take that latter approach, we can't agree, so you agency figure it out. Well, DHS under President Biden might see it one way, and DHS under President Trump could see it completely differently.
And
in
that
fact,
happened
one of the
EPA right when Chevron was happening.
It did, and that's one of the strongest criticisms of Chevron is that if you give complete deference to agencies, you can have these flip-flops depending on who's in charge of the administration of the agency. And so the notion of Chevron that you're giving deference to agency expertise really means that you're giving deference to the political leadership in charge of the agency, and you're not relying so much on their expertise, but upon the policy decision of whoever is in charge. But that said, it is important, what Congress says. If Congress produces legislation, say, that affects critical infrastructure, and it doesn't answer a question, well, that makes it harder because an agency trying to leap into the void might have trouble showing that it had a statutory basis to get near the void in the first place.
Right.
However, let's suppose that there's Cercia amendment. And the Cercia amendment says, look, we don't really know the right way we don't know the right regulations or security controls to impose upon water infrastructure, energy or food and agriculture. And we are authorizing the Department of Agriculture, the Department of Energy, the Department of Commerce, and DHS. We are authorizing you to use your best judgment to come up with an approach that will meet these objectives, which we, Congress, will describe. And in that situation, where Congress has clearly made the delegation to the agency, then the agency is on much stronger grounds to make its own interpretation and to sustain it against a later attack. Because it's not just that Congress gave them the opening authority, but Congress said, we want you to decide this.
Right.
And in my reading of Loper-Bright and the repeal of Chevron, the court is saying, if Congress specifically delegates authority and responsibility to an agency to make a decision on a complex or unknown problem, we're going to respect what the agency does as long as, in effect, it's rational and not arbitrary and capricious. And by the way, as others have said beyond me many times, if the best thing you've got in challenging a regulation is to say that it has no rational basis and it's arbitrary and capricious, you're not going to get very far.
Right.
Because few agencies are going to put stuff out there that's completely irrational on its face.
Right. Well, yeah, and I think that addresses what I've seen as maybe the biggest concern at a more technical level is, a lot of the reason that Congress pushes the specifics off to agencies is Congress doesn't have the technical expertise. And I've seen similar concerns about with this decision. Does that mean that the courts are going to try to make all these technical rulings and this and that? And I think you kind of a few times kind of touched around that of, in most cases.
But wait, there's more.
Okay.
So look, I've heard this technical expertise. I think the dissent says agencies are these vast repositories of technical expertise, and how can you tell us that courts?
Right.
I think there's 94
exactly
federal judicial. How can you say that courts ought to be making decisions on these things? Well, I mean, if you look at the larger universe of civil litigation in the federal courts, judges deal with technical issues of every kind imaginable all of the time, and sometimes on subjects that are extraordinarily remote and dense and difficult. It is not an unusual thing for the judiciary to resolve technical issues. Moreover, it is not as though some of the criticism suggests you're going to give this to some judge that Trump appointed who's going to make some terrible decision who knows nothing. Well, maybe, but maybe it's some judge that Biden appointed who makes a policy-driven decision. But it doesn't actually work that way. I mean, if there's a contested regulation after the demise of Chevron, there's going to be a bunch of briefs that are filed arguing both sides of it. And if it has important policy or legal implications, there's going to be briefs from amici curiae. So the record in front of the judge is going to be quite full and elaborate. So the judge isn't just sort of making this decision on his whim. They're going to be making it after a thorough advocacy process where the judge will have plenty of things to consider and plenty of positions to weigh. And moreover, even if one judge says, I hate that statute and that objective of that regulatory agency, that's far from the end of it, because it could well be appealed, and it could even be appealed beyond a circuit to the Supreme Court. So I'm not so troubled by the fact that we're asking courts to make more technical judgments. I think they're capable of doing it. I'm a little worried that there's going to be some, fantastic flurry of challenges just because people maybe misunderstand the repeal of Chevron, and that we're going to have even more clogging and delays in the federal court process. But, putting difficult technical issues involving matters of national policy before the courts doesn't bother me as much as maybe it bothers the dissent. And one other thing, do we really think that agencies actually are always the source of expertise, distinct from opinion, purpose, premise, assumption, or objective? There's a difference. I mean, there are places, where the agency may have a huge amount of expertise, take the EPA on particulate emissions, but the regulations that may get challenged are not so much driven by its expertise, but by policy decisions that are built upon its expertise, but reflect a particular objective of an administration. And we have to always remember that, the polarity could switch.
Right. Well, I think that brings maybe it down to I don't know if silver lining is the right term, but I would say transparently, I think my concerns with regard to the repeal of Chevron deference do align more with some of the issues brought up in the dissenting opinion regarding very hyper technical things of, how do you apply this statute to this very specific protein or fish or something? And I understand, sort of both interpretations, but I think maybe a compromise between the two positions that I think, again, made a pretty good case for is agencies then just need to make sure that when, they have the authority when they issue regulations, and Congress needs to put a little more forethought. I would argue, not from what you said, but personally, having read a lot of legislation, I think Congress needs to put a little more forethought into when they issue authority, what are the bounds of that. But I think regarding what you mentioned with agencies should have probably seen this coming and also should know how to adapt accordingly, where, maybe again, I only know this at a surface level. I'll be transparent on that, but I think what I have learned here today, at least, has been, agencies should have seen this coming, and agencies, for the most part, may have, and if it's, worth its weight, kind of as CMMC is constructed, the time has probably already been put into it to ensure that it is not unassailable, but less assailable to capricious challenges.
I mean, where you get into trouble is if you take adventures.
Right.
And unfortunately, even though I sympathize with many of the things that I might legally call adventures, there are examples in the current administration of where such adventures are underway.
Sure.
And those things are going to be vulnerable. And there will be situations that will worry you and I on the infrastructure side, where we're likely to say, gee, we don't have any means to actually tell Food and Agriculture of what measures they should take in order to protect, their data-driven Internet of Things, emerging facilities. And there are going to be problems where we would sure wish that agriculture would just put out something that was a minimum set of standards or process of reporting. We'd like that because we're just kind of otherwise hoping that the private market will do it. But that's going to be hard without some statute that says you can do it, and we have to hope that Congress will provide that statute. And appreciate that the stakeholder community out there, these zillions of businesses and people who are the subject of regulations, they actually have, an interest and considerations that weigh in here.
Right.
And it's much easier to predict and plan where a statute tells you what to expect than it is to react and recover where an agency decides to take an adventure and impose an obligation that you had no reason to anticipate earlier.
Right. And I think that's kind of touches on, in my preparations, one of my observations as well is, again, everyone's anticipating all of these challenges, but ultimately most organizations don't want to innovate or operate in an undefined landscape. So I think I think people, obviously there's pushback between overregulation, underregulation. That's not exactly what I'm saying, but I think that it's not as black and white. I don't think that organizations hate all regulation across the board, because that kind of shows them the sandbox that they're playing in without, with a defined future in some capacity. Obviously things can change, new regulations, whatnot, but and it also, if agencies are, take, like CMMC has been in development for years now, right? If most things are being as prudently developed, then people know what's on the horizon anyway. It's not a quickly developed set of rules or regulations, kind of like the water sector governance that you had mentioned, where just kind of it was a snap response to a series of incidents. So I think maybe those are kind of my observations from this.
Regulations are not going away.
Right. Well, I think that's
are administrative
as an underlying
agencies.
statement. I think that's very, very important as a statement in and of itself.
And the repeal of Chevron, it is not a switch in polarity, an inversion of everything that was into something new, different, and bad. There will be some areas of instability. There will be challenges that aren't meritorious. There will be people that shop for forums and judges, and people are looking to get, some regulations enjoined for a while. It's going to take a while. It's going to take a while to shake out. And there are going to be some outcomes of post-Loper Bright APA actions that you or I, from our personal vantage points, won't like.
Right.
But, I mean, the fundamental argument that we are a nation ruled by law ought to mean that you don't give deference to agencies just because they have some responsibility. You ultimately recognize that there are distinct and important roles of the executive branch, the legislative branch, and the judicial branch, and you do expect agencies to abide by and conform to the statutes upon which their actions are based. So, as a lawyer, I'm not so bothered by the repeal of Chevron. And as a security person, maybe I'm more concerned because I don't like the instability or uncertainty. But in the end, sound regulations produced by thorough work that are carefully explained, that don't get too far from their statutory basis, I think they're going to be okay. And as a matter of overall good governance, I'm inclined to like the world after the repeal of Chevron better than the one before.
And I think that's maybe a great concluding note as we come up on time here, because I think my maybe most significant takeaway from this, or most surprising from this interview, is I came into this conversation maybe with a lot more of the doom and gloom perspective, and you've kind of pulled me to the other side on that. I'm less concerned about it, I would say. I still, have some nitpicking on the technical side, but I think I'm not worried that this is a cataclysmic event on the horizon, which is where I was previous to this.
Yeah,
I think our audience will have a similar reaction.
when I first read about the decision and I heard about the dissent, I said, oh no, the expert agencies are suddenly going to be told they can't do anything that we need.
Right.
But agencies are not always expert. And sometimes opinions about expert questions can actually be subject to widespread and intense disagreement over a span of differences. And so we want to be careful, about sort of blindly assuming that because an agency has a general charter or a broad statutory authority, that we should just let them decide what the law is whenever they do and however they want to change it. We ultimately do want to kind of make the laws work and oblige agencies to do their work in accordance with law and without those adventures that I mentioned. Do I think that our national ability to respond to infrastructure threats will be materially aggravated by the demise of Chevron? No. Do I think it will be incidentally frustrated? Yes. Do I think this points to a need for Congress to give better, broader, clearer authority to the sector responsible agencies? Yes, I think they do. Do I think that would actually surprise the most knowledgeable people at Congress? No, I think Congress knows this.
Right, and I think what maybe comes to mind here is it's non-direct translation to the situation, but there's a saying, especially in the negotiation space, that the hallmark of a good compromise is when nobody's happy.
Right.
And I think maybe that's kind of where you've pulled me to on this spectrum, in that I'm sure those challenging Chevron for years were kind of hoping for a much more deregulated end state. And I think, again, folks like me who just saw the surface level were much more concerned with the doom and gloom outcome, where what do we do now? And I think maybe the end result is more defined, at least than I saw, but also maybe more promising in a certain sense if, everything goes,
This decision, which is the culmination of 8 years erosion of Chevron, tells everybody to do their job better.
I think that's maybe the best takeaway that I can think of, is Congress can't, kick the can over to agencies with no explanation. Agencies can't do what they want, or the executive branch in general. And the three branches need to work as intended. That's a very interesting takeaway, because again, I was maybe predisposed much more on the doom and gloom side before this conversation. I'm curious to see where our audience lands, but I think you've been very persuasive on that.
Thank you. Well, we'll see. I mean, I'm expecting some disagreement, but I will try to endure it.
Disagreement's not always a bad thing. That's how ideas are formed. Well, thank you so much for your time. Where can our audience members reach out to you, find you?
So I'm a frequent poster on LinkedIn. I put something up yesterday on the problems that CrowdStrike has endured, and somehow it's generated close to 12,000 observations. So if you want to see my ideas on a kind of regular basis, you might follow me on LinkedIn. You can message me on LinkedIn, or you can send email to my law firm address, which is rmetzger@rjo.com.
Great. And I'm sure numerous aspects of the CrowdStrike incident we will also be reaching out to you regarding. Similarly, our audience can reach out to Mission Critical at missioncritical.org or on LinkedIn. Well, thank you so much for your time, and I think this went great. I'm surprised with the insights that I'm walking away with, and I hope our audiences as well. And I hope to have you back for future discussions, especially where maybe I'm very out of my depth on other legal issues like this.
Thank you.
Thank you so much.